Hi, I'm attorney Ron Ruskin. In this video, I want to talk about uncontested divorce in Ohio. An uncontested divorce is where husband and wife agree upon the terms of the divorce, but only one of the spouses will go to the final hearing, or where the defendant spouse has been served with papers, but has not filed any objection. An uncontested divorce is commonly used when husband and wife still live together at the time the divorce is about to be filed. By contrast, dissolution of marriage requires separation and separate residences. To avoid this requirement, just file a divorce action. An uncontested divorce is also used where one spouse does not want to go or cannot go to the final hearing. Maybe one spouse does not want to miss work, or lives out of state, or a good distance from the court. In an uncontested divorce, only the plaintiff must go to the final hearing. The divorce can still be by agreement, where both husband and wife sign all the papers and agree upon all the terms of the divorce. What about where the spouse will not sign papers, but will not contest the case? The defendant spouse is served with the divorce complaint, and if 28 days go by after the service and no answer or objection is filed, the case can be set for final hearing as an uncontested divorce. Let's go over the documents which are required. First, there is the complaint for divorce. It sets forth the name and addresses of the parties. Party filing for the divorce is the plaintiff, and the other spouse is the defendant. The date and place of marriage, the names and dates of birth of any minor children of the marriage, and whether the wife is now pregnant. That the plaintiff has lived in the state of Ohio for more than 6 months prior to the filing of the complaint. That there has been residency in the county for 90 days. That neither party is in the active duty of military service, or if they are in active duty, that they have signed a waiver authorizing the case to proceed to final hearing without delay. That the plaintiff is seeking a divorce, usually upon the basis of incompatibility, or living separate from their spouse for more than 1 year, and what the plaintiff is seeking. For example, a reasonable division of the marital property, if spousal support is wanted, and if there are minor children of the marriage, the allocation of parental rights regarding the minor children. If the divorce is by agreement, the second spouse signs a waiver acknowledging receipt of the divorce papers and consenting to the matter being set for final hearing. This is so the clerk doesn't have to serve the second spouse with papers, and the case can be set for final hearing. If a spouse will not sign a waiver, they will have to be served with a divorce complaint by the clerk of courts, usually by certified mail. In uncontested divorces by agreement, the separation agreement of the parties is referred to. Each party is ordered to follow the provisions of the separation agreement. In cases where the defendant spouse will not sign a separation agreement or the final divorce decree, the terms of the divorce and what is to happen to all assets and liabilities will have to be put in the divorce decree along with the findings of the court. Some courts require the filing of an affidavit of income, assets, and liabilities, and an affidavit of property. This is so the court can see the income of the parties and the value of all assets and the debts of the parties. The Ohio Supreme Court has adopted financial affidavits which must be honored in all counties. Some counties have their own affidavits.
Use either the Ohio affidavits adopted by the Supreme Court or the local affidavits, whichever is easier.
If your county has the requirement of a financial affidavit or affidavits, the plaintiff must complete and file them with the clerk of courts. For the final divorce hearing, there is the judgment entry, decree of divorce. This document repeats much of the language of the complaint for divorce and says that the divorce is granted. In uncontested divorces by agreement, a separation agreement is often used, and each party is ordered to follow the provisions of the separation agreement. In cases where the defendant spouse will not sign a separation agreement or the final divorce decree, the terms of the divorce and what is to happen to all assets and liabilities of the parties will have to be put in the divorce decree.
If you want to save money and file your own dissolution or divorce, but don't want the frustrations of doing the papers yourself, I can help. I make sure all forms are completed and all proper and required language is in your papers. I prepare papers for all Ohio counties and review the local court rules for all counties. Visit my website, dissolutionohio.com.